for Public Service Commission hearing in Docket 20-3517, application of Rocky Mountain Power for a deferred accounting order regarding costs incurred due to the COVID-19 public health emergency. I've confirmed that Commissioners David Clark and Ron Allen are also on the line for this hearing. Before we go to appearances, I'll just remind everyone, if you're not speaking, please mute your phone. And I know sometimes it's hard to remember to unmute it when you need to speak, but that helps the audio quality quite a bit. And then please identify yourself when you speak too, and that helps the transcript be more accurate when we do that. So with that, why don't we go to appearances for Rocky Mountain Power?
Yes, thank you, Chairman LeVar. This is Jacob McDermott.
Okay, thank
Pardon
you,
me?
Mr. McDermott.
Sorry, this is Jacob McDermott, counsel for Rocky Mountain Power.
Thank you. For the Division of Public Utilities?
Good morning and thank you. This is Patricia E. Schmid, SCHMID, representing the Division of Public Utilities. I am an Assistant Attorney General. Thank you.
Thank you, Ms. Schmid. And for the Office of Consumer Services?
Yes, this is Robert Moore, Attorney General's Office, representing the Office of Consumer Services. I have with me today as our witness, Donna Ramos. She's a consultant for the office.
Okay, thank you, Mr. Moore. Any preliminary matters before we move to Rocky Mountain Power?
Nothing for the company. Thank you, Chairman.
Okay, thank you. I'm not hearing anyone else indicate anything preliminary, so we'll move to Rocky Mountain Power now. Mr. McDermott.
Thank you. The company would like to call Stephen R. McDougall to testify for the company.
Okay, thank you. Mr. McDougall, are you on the line?
Yes, I am.
Do you swear to tell the truth?
Yes.
Okay, thank you. Mr. McDermott, you can go ahead.
Mr. McDougall, would you please spell your full name, state your title with the company, and provide your business address, please?
Yes. My name is Stephen R. McDougall. The last name is McDougall. I am the Director of Revenue Requirements for the company. My business address is 1407 West North Temple, Salt Lake City, Utah, 84116.
Thank you, Mr. McDougall. And have you prepared, first I would ask if you are prepared to adopt the company's application and its reply comments as your testimony in this proceeding?
Yes, I am.
And have you prepared a summary of that testimony for us today?
Yes.
Could you share that with us, please?
Yes. On April 3rd, 2020, Rocky Mountain Power, a division of Pacificorp, submitted an application for an accounting order authorizing the company to record a regulatory asset associated with costs incurred as part of the company's response to the COVID-19 public health emergency. On July 21st, 2020, the company filed reply comments responding to the comments of the Division of Public Utilities and the Office of Consumer Services. Before proceeding with the summary, there is one correction to the company's reply comments filed on July 21st, 2020 that I would like to make. If I could have the parties turn to page 3 of the reply comments. This is in the section 3. It is the second paragraph. It begins with waived late fees. In that sentence, the word included should be deleted and replaced with the words tracked for possible inclusion. Therefore, the sentence as rewritten should read, waived late fees should be tracked for possible inclusion in the deferral account. Usually I wait to see if everybody's got it. Where I cannot see, I'm assuming that everybody has made that change, and I will proceed. In the original application, the company noted that beginning March 16th, in response to the COVID-19 public health emergency, Rocky Mountain Power suspended disconnection activity for non-payment on all non-managed accounts and, upon request, waived late fees and reconnection fees for these same customers. These actions were intended to assist customers facing extraordinary circumstances as a result of the pandemic and to support Utah's ongoing efforts to limit and slow the spread of the disease. Rocky Mountain Power asked for authorization from the Commission to defer, for potential future recovery, certain costs incurred related to the company's response to benefit customers during the COVID-19 public health emergency. To account for the unanticipated costs of its response, the company requested that the Commission approve the establishment of a deferral account to record the incremental costs associated associated with the increase in bad debt expense associated with the COVID-19 emergency. The company also intends to establish a tracking account to monitor additional costs associated with the COVID-19 emergency, including any fees waived, for possible approval for deferral and recovery in a future proceeding. Even though it is not currently possible to fully anticipate the scope of the cost impacts related to the COVID-19 emergency, the company filed for authorization for deferred accounting at that time because of the potential magnitude of the costs. The risks related to Rocky Mountain Power's response are also well outside the ordinary business risks for the company. Deferred accounting will help the company track the costs driven by COVID-19. The company is unable to fully estimate the total cost that will be incurred due to its COVID-19 responses at this time, given the many unknowns, including how long the emergency situation is likely to continue. The company is proposing to use calendar year 2019 as its baseline for bad debt expenses, as shown in the application. Costs incurred in excess of the baseline would be recorded in the deferral account. The company also proposed to record a carrying charge on the COVID-19 related deferrals at the Commission-approved carrying charge rate. The company acknowledges that the Commission's approval of deferred accounting treatment for COVID-19 related costs will not in itself constitute approval of ultimate recovery of these costs. Recovery of the costs would be subject to a prudence review and a final decision on rate recovery in a future regulatory filing. In recognition of the unanticipated and unprecedented nature of the COVID-19 emergency and potential need to include additional cost categories as the situation evolves, the company proposed to provide updates approximately 30 days after the end of each quarter to the Commission, the Division of Public Utilities, or DPU, and the Office of Consumer Services, or OCS, and any other interested parties. In these quarterly updates, the company commits to provide deferral amounts for bad debt expense and any other COVID-19 costs identified and being tracked as of that time. The company proposes the first quarterly update filing be due on or about November 1st, 2020, which is roughly 30 days past the end of the third quarter of 2020. In the reply comments filed on July 21st, the company noted that the OCS and the division did not contest the company's proposed method for calculating and tracking bad debt expense. The company also agreed to provide additional reporting as requested by OCS, to seek approval from the Commission before including any additional COVID-19 related expenses in its regulatory asset, and to seek approval from the Commission if it believes it is appropriate to extend the deferral beyond December 31st, 2020. The company will continue to track other costs and, as stated in the application, if the company determines these costs should be deferred, it will make a separate filing in this docket to provide an explanation why deferral and potential recovery is appropriate and what baseline will be used to calculate the deferral for that cost category. This would allow for an opportunity for interested parties to provide input, conduct discovery, and make recommendations to the Commission. Consistent with past practice of regulatory assets and liabilities, the company should be permitted to book a carrying charge on the amounts in the deferred account. The company is carrying the bad debt deferral costs until it is permitted to recover them, and therefore should be allowed to apply a carrying charge to the amount in the deferral account to account for the time value of money similar to other deferrals. The OCS argued that this results in a benefit to shareholders as a result of the COVID-19 epidemic. However, the company is not asking for a full rate of return, but the lower customer deposit rate, which is applied to most deferrals. This does not provide a benefit to the company, just provides a return to the company to cover the time value of money. In conclusion, I recommend that, based upon the reasons above, the Commission approve Rocky Mountain Power's request for an accounting order to record COVID-19 related costs, including the deferral of late fees waived and a carrying charge. Not including the deferral of late fees waived. That is something we will request later. The company agrees that whether recovery of the deferred expenses are appropriate should be considered at a later proceeding. The company also agrees to provide reports as requested by the OCS and to seek permission from the Commission before including any additional categories of COVID-19 related costs or extending deferrals beyond December 31st, 2020. Thank you.
Thank you, Mr. McDougall. I have one follow-up question. Oh, pardon me? Okay, I have one follow-up question based on your summary. The office in their reply comments noted that there's a materiality consideration with respect to deferred recovery of deferred costs. What is the company's position on the materiality of deferred costs?
Well, as of right now, the company does not know the materiality of these costs. As mentioned, we are still tracking, and what we do know is the company has seen an increase in our arrearages and our number of customers that are past due. We know that that will be followed by bad debt expense. We just do not know the level at this time. When the company seeks recovery of those costs, if we file for recovery of those costs, it will all depend upon the facts and circumstances at that time, and the company will need to put forth its case, and the Commission will need to make a decision based upon the facts as presented.
Thank you, Mr. McDougall. The company would like to make Mr. McDougall available for cross-examination at this time.
Okay, this is Thad LeVar. Thank you, Mr. McDermott. I don't believe we had a motion to admit any of these materials in as evidence. Did you intend to do that?
Oh, yes. My apologies. The company would seek to admit the application and reply comments adopted as Mr. McDougall's testimony into evidence at this time.
Okay, Ms. Schmidt or Mr. Moore, if you have any objection to that, please speak up. I'm not hearing any objection from either, so the motion is granted. Thank you.
Thank you.
And with that, Ms. Schmidt, do you have any questions for Mr. McDougall?
Yes, I do. This is Patricia Schmidt representing the division. Mr. McDougall, in your comments, you mentioned non-managed accounts. What is a non-managed account?
Okay, as noted in the original filing, the company has certain large accounts which are managed. Those accounts are not eligible and are not included in this deferral request.
How are these accounts managed?
These accounts, the company has a group that manages our large contracts, and that basically they have what's called an account manager. Their account manager works with the customers and deals with them. They are, like I said, our larger accounts.
Thank you very much. I have no further questions.
Thank you, Ms. Schmidt. Mr. Moore, do you have any questions for Mr. McDougall?
No questions from the OCS, thank you.
Okay, thank you, Mr. Moore. Mr. McDermott, do you have any redirect follow-up to Ms. Schmidt's questions?
No redirect at this time. Thank you, Chairman.
Okay, thank you, Mr. McDougall. I'll go to Commissioner Allen. Do you have any questions for Mr. McDougall?
I do not.
Okay, thank you. Commissioner Clark, do you have any questions?
Yeah, pardon me. Yes, I have a question. It relates to the statements, Mr. McDougall, that you made about materiality and the subsequent showing that the company will make with respect to the materiality of the amounts in the deferred account if it's authorized. And I just want to make sure that my understanding is clear and the record's clear that as to the following point, what I understood you to say is that the company accepts that it will have a burden to establish that the costs that for which it seeks recovery are material. Is that true?
That is true. We will be bound to show, based upon the legal precedents, the criteria for a deferral, which includes some level of materiality.
Thank you. That's the only question I have.
Thank you, Commissioner Clark, and I don't have any additional questions. So thank you for your testimony this morning, Mr. McDougall.
Thank you.
Mr. McDermott, do you have anything else from Rocky Mountain Power?
No further witnesses from Rocky Mountain Power and nothing else at this time. Thank you, Chairman.
Okay, thank you. Ms. Schmidt, we'll go to you.
Thank you. The division would like to call Mr. Jeff Einfeld as its witness. May he please be sworn?
Mr. Einfeld, are you on the line?
Yes, I am.
Do you swear to tell the truth?
Yes, I do.
Okay, thank you. Ms. Schmidt, go ahead.
Good morning, Mr. Einfeld. Could you please spell your full name for the record?
My full name is Jeffrey S. Einfeld. It's Jeffrey, middle initial S as in Samuel. Einfeld is EINFELDT.
By whom are you employed, and what is your title?
I am employed by the Division of Public Utilities. I am a technical consultant.
What is the business address for the division?
Business address is 160 East, 300 South, Salt Lake City, zip code 84114.
In connection with your employment by the division, have you participated on behalf of the division in this docket?
Yes, I have.
Did you participate in the activities leading to the filing of the DPU's comments dated June 1st, 2020 in this docket?
Yes, I did.
Do you have any changes or corrections to those comments?
No.
Do you adopt those comments as part of your testimony here today?
Yes.
The division would like to move for the admission of the division's comments filed June 1st in this docket.
Okay, thank you, Ms. Schmidt. Mr. McDermott or Mr. Moore, if either of you have an objection to this motion, please indicate it.
No objection from the company. Thank you.
No objections from the OCS.
Okay, thank you. Motion's granted. Ms. Schmidt, you can go ahead.
Thank you. Mr. Einfeld, do you have comments you would like to make today?
I would just like to refer the commission and the other interested parties to the conclusion section of our initial filing, our action request response, which states the following. The division believes Rocky Mountain Power's application for a deferred accounting order for bad debt related to costs identified with regard to the COVID-19 public health emergency meets the burden of an unforeseen and an extraordinary event generally. Materiality of the cost is unknown at this time. The division recommends the application be approved conditioned on review and approval of actual costs submitted in the future pursuant to the method described in the application. The division also recommends that Rocky Mountain Power analyze, track, and report potential COVID-19 related savings to mitigate the costs. With these conditions, the division believes approval of the application is just, reasonable, and in the public interest. And that concludes what I have to say.
Thank you. Mr. McDermott is now available for cross-examination questions and questions from the commission. The division has nothing further at this point unless we have redirect.
Okay, thank you, Ms. Schmidt. Mr. Moore, do you have any questions for Mr. Einfeld?
I have no questions.
Thank you. Mr. McDermott, do you have any questions?
No questions. Thank you very much.
Okay, thank you. Commissioner Clark, do you have any?
I have no questions. Thank you.
Thank you. Commissioner Allen?
Thanks. I have no questions.
And I don't either. So, Mr. Einfeld, thank you for your testimony this morning. And Ms. Schmidt, I think you... Oh, go ahead, Ms. Schmidt.
With that, the division has nothing further.
Okay, thank you. We'll go to Mr. Moore.
Yes, the Office of Consumer Services called Donna Ramus and asked that she be sworn.
Thank you, Mr. Moore. Ms. Ramus, are you on the line?
Yes, I am.
Do you swear to tell the truth?
Yes, I do.
Okay, thank you. Mr. Moore, go ahead.
Ms. Ramus, could you state and spell your name, your business address, and state for whom you are testifying today?
Yes, my name is Donna Ramus, D-O-N-N-A, last name R-A-M-A-S. My business address is 4654 Driftwood Drive, Commerce Township, Michigan, zip code 48382, and I'm testifying on behalf of the Utah Office of Consumer Services.
Have you reviewed the record in this case, Docket 20-035-17, and did you assist in the preparation of the OCS June 2nd, 2020 initial comments?
Yes, I did.
Do you have any changes you'd like to make to these comments at this time?
Yes, I do have a change beginning if the commissioners and parties can turn to page 6 of the initial comments filed June 2nd. Under the area of carrying charges, and as a brief background to these changes, I'd like to explain that at the time I prepared or assisted in the preparation of these comments, I was under the understanding that the requested carrying charges would be based on the rate of return, which would include an equity component. And upon reviewing the company's reply comments, I realized that that assumption was an error and that a shareholder return would not be included as a component of the carrying charges. So as a result of that understanding, at the bottom of page 6 under requested carrying charge, I would like to delete the sentence that states included in carrying charges are not only debt, but also a profit to shareholders through the equity return component. That sentence should be deleted in full. And then if you turn to the next page, page 7, at the very end of, again, at the time I wrote this, I was under the understanding or wrong assumption that a shareholder return would be included. And based on my corrected understanding, I would like to delete the words particularly distasteful and replace it with disappointed or disappointing. And then that would complete the corrections.
Other than those changes, if I ask you questions concerning the statements, arguments, and recommendations made in the June 2nd initial comments, will your answer be the same as the statements, arguments, and recommendations contained in the June 2nd comments?
Yes, they would.
Do you adopt the June 2nd, 2020 initial comments as your testimony today?
Yes, as corrected, I do.
The office asks for omission of the June 2nd comments. That includes for the admission of the comments.
You're talking about both, are you talking about both comments and reply comments, Mr. Moore, or just the comments?
Just the initial comments as testimony. The reply comments were legal in nature, and they're in the record.
Oh, okay.
So we thought we'd just limit her testimony to the initial comments on June 2nd.
Okay, thank you. That's clear. Mr. McDermott or Ms. Schmidt, any objection to the motion?
No objection from the company. Thank you, Chairman.
No objection from the division.
Okay, thank you. The motion's granted. Mr. Moore, you can go ahead.
Have you prepared a statement of the OCS's position in this document?
Yes, I have.
Please proceed.
Okay, good morning, Chairman and Commissioners. At this stage of the docket, there is much that the company and the OCS are in agreement on. The company agreed in its reply comments that the determination of whether or not the requested regulatory asset meets the standard for deferred accounting orders and whether recovery of the deferred expenses is appropriate should be considered in a later proceeding. At that time, more information regarding both the magnitude of the costs incurred and the impacts of the public health emergency should be known. The company has also agreed to provide the additional information recommended by the OCS in the quarterly reports it proposes to file in this docket and agrees that it will seek approval prior to including additional COVID-19 related expenses in a regulatory asset. The company also agrees to seek commission approval if it believes it is appropriate to extend the deferral period beyond December 31st, 2020. At this time, I am only aware of a few disagreements between the company and the OCS in this docket. The first difference is associated with late fees. And again, this is with the clarification provided earlier today by Mr. McDougall. The OCS recommends that the write-off of incremental late fees caused by COVID-19 public health emergency not be allowed for inclusion in the requested regulatory asset at issue in this hearing. And again, this is the incremental write-off of late fees that would be included as part of bad debt expense that would potentially be included in the regulatory asset. Additionally, in light of the significant impact on customers resulting from the public health emergency, the OCS recommends that carrying charges not be applied to the COVID-19 related deferrals. The OCS also recommends that whether or not there be a sharing of the amounts accumulated in the regulatory asset between RMP and its ratepayers should be decided by the Commission at a future time when the full extent of the public health emergency on Utah citizens and businesses can be evaluated. I don't believe that, or at least I'm not aware of the company taking a position on potential sharing of the amounts, so I'm not certain if that's in dispute or not, but it's something that the office recommends be determined at a future time. And that concludes my statements. Thank you.
Ms. Ramus is available. Excuse me. Ms. Ramus is available for questions from the Commission and cross-examination.
Okay, this is Thad LeVar. Thank you, Mr. Moore. Ms. Schmidt, do you have any questions for Ms. Ramus?
The division has no questions. Thank you.
Okay, thank you. Mr. McDermott, do you have any questions?
No questions from the company either. Thank you, Chairman.
Okay, thank you. Commissioner Allen, do you have any questions?
No questions. Thank you.
Okay, Commissioner Clark.
I have no questions. Thank you.
Okay, thank you. And I don't have any either. So thank you for your testimony, Ms. Ramus.
You're welcome.
Mr. Moore, anything further from the office?
The office has nothing more. Thank you.
Okay, thank you. Anything further from any party at this point?
Nothing further from the company. Thank you.
Nothing further from the division. Thank you.
Nothing further for the OCS.
Okay, thank you all for your participation in this hearing today. We will issue a written order on this matter. At this point, the hearing is adjourned. Thank you.
Thank you.
Thanks.